So what's a durable power of attorney? Hi, I'm Daniel Hunt, and I am a certified specialist in estate planning, trust, and probate law here in California. Today, we're going to talk about what a durable power of attorney is, why you need one as part of your estate plan, and how you create one. So what is a durable power of attorney? It's a document that authorizes someone else to act on your behalf for you. It's called durable because it continues to be effective even after you've lost capacity. This is different from a traditional power of attorney, which becomes void and you can't use it once you've become incapacitated. A durable power of attorney is a very helpful incapacity planning tool because this ensures that someone, a family member, or whoever else you've chosen, can take care of your finances if you become incapacitated. This can avoid a lot of confusion as to who's going to be in charge of paying bills or managing investments if you are incapacitated and can't take those actions for yourself. The most common type of power of attorney is a general durable power of attorney, otherwise known as a financial power of attorney. This appoints an agent to act on your behalf in many different areas, such as banking, taxes, purchasing real property, or even making gifts on your behalf. Another type of power of attorney is a springing durable power of attorney. This power of attorney only springs into effect once you've become incapacitated. Your agent can't act on your behalf until you've lost capacity. You can tailor these documents to be very specific with what actions your agent can take on your behalf. You can give a power of attorney that only allows an agent to go and withdraw money from the bank for you. You can give a power of attorney that only allows your agents to file a tax return for you. These documents can be tailored to your specific needs, and that's very important to understand. Many people wonder, if you have a revocable living trust as part of your estate plan, do you really need a power of attorney as well? The answer is yes. And the most compelling reason as to why you need one is because there are so many assets that aren't titled in your trust that would be subject to a power of attorney if you can't take actions with them. For example, life insurance. Life insurance typically isn't put into your trust. It's just a contract that says if I die, then give money to this person over here. But if you're incapacitated and you need to withdraw any cash value that may be part of that life insurance or change something with regard to that contract, you have to have a power of attorney. Another one are retirement accounts. Retirement accounts are not held in your trust. Those remain in your name while you're alive. If you become incapacitated, the trustee of your trust cannot manage those retirement accounts for you. They must have a power of attorney in order to do that. So the answer to should I have a power of attorney even if I have a trust is yes. So to illustrate this point, we had a case where a client came to us and had an incapacitated husband. He had retirement accounts and they had a trust as part of their estate plan, but she did not have a power of attorney for him. Without that power of attorney, she was unable to go and access the funds that were held in his retirement accounts for his care. What we had to do instead was go and establish a conservatorship over her husband. This took 3 months and about $5,000 in fees to go get that conservatorship established. Much more difficult to go that route as opposed to having a simple power of attorney that would have been drafted for his wife and allowed her to access those retirement funds on his behalf for his care. So the last question is, how do I create a general durable power of attorney? While there are forms online that you can get or even go to stationery stores to buy these things, it is best that you seek the counsel of a qualified estate planning attorney that can counsel with you about the effects that this document's going to have and the powers that your agent will have. Like I said before, these can be tailored very specifically to your needs, or they can be very general and let all the powers be held by your agent. But it's important that you understand what these powers do, who's going to hold them, and what effect they'll have on your estate plan. That's why we recommend counseling with an experienced estate planning attorney before you sign these documents. Once you have your power of attorney drafted, you have to sign this document in front of a notary for their notarization or in front of 2 witnesses. It's also important that your agent have this original document with them whenever they are acting on your behalf. So there you have it. The answer is to what a power of attorney is, how you create one, and whether you need one. We hope that you've enjoyed this video, and if you have any further questions, we encourage you to contact us at our office. Thanks. We hope you found this video helpful, and if you'd like more information on estate planning or our law firm, you can check us out on Facebook, Twitter, or our website that are listed below. If you'd like to contact us, you can do so at 916-488-9788 or at our email info@dhtrustlaw.com. Thanks.